Get started. Hey, it's 3 o'clock, so we are ready. And we may adjust the order because as it gets this time of year, several people have several meetings at the same time. So at this time, I'm going to ask Chairman Shaw to open us in prayer.
Thank you, Mr. Chairman. Let's bow our heads, if you will. Gracious Heavenly Father, accept our thanks for bringing us all here together today safely. We ask your blessings upon us as we conduct this meeting. Just be with the chairman as he leads all of us, Lord, and those who are speaking today. Help us to all act in ways that are pleasing to you and pleasing to our constituents and great for the state of Georgia. Amen.
Thank you, Chairman. And with that, if anybody, I assume we've got a sign-up sheet up front, so if anybody wants to speak to any bill, just make sure you put what bill number you want to speak to next to it, and then we will get to you. As I mentioned, in deference to Representative Gravely, we're going to let him go first, and that is House Bill 795. Come on up.
Thank you, Mr. Chairman, members of the committee. I appreciate the consideration on our schedules. This House Bill 795 is a department bill. I was unaware in the state of Georgia that certain agencies, certain departments are allowed or have the capability to do nationwide background checks and fingerprinting. I was also unaware that two of our departments that handle very sensitive information on Georgians and oftentimes some personal information do not have the capability of doing nationwide background checks and fingerprints on employees that would be viewing or handling such information. For example, Department of Community Health has the capability for private home care, personal care homes, community living arrangements. Secretary of State's office, under that, the massage therapists have that capability, music therapists have that capability, and for practical reasons. However, this bill gives, House Bill 795, gives the Department of Labor that capability, which currently they do not have. There was, if you'll look down on the bill, the first page, lines 14 through 20, Representative McClain came to me with a little bit of concern on why, in order to give the Department of Labor the capability for fingerprinting and nationwide background checks, we would need to strike these particular lines dealing with the Commissioner's ability to promulgate rules and safety standards. This is seen throughout the code section. So this just, what we're doing here by striking that section 1 is just making it clean. Also my understanding is this language has to be approved by the Federal Bureau of Investigation, which the Commissioner would not have control over. However, if you will look, starting with line 20, to prescribe such rules and regulations consistent with the terms, intent, and purpose of this title, except for Chapter 9 of this title, necessary for the proper administration and enforcement thereof. The Commissioner is able to do that all throughout the code where this language is found. So simply, this bill would give the authority or the capability for the Department of Labor to do a nationwide background check and fingerprints on employees that are coming into the department, which they currently do not have.
And if I may ask the first question, is it not true that you're basically carrying the same bill for the Department of Revenue we're just trying to get all the departments up to federal standards?
Absolutely. Federal standard,
or federal compliance, I guess.
Compliance is a better word.
Does anybody have, any committee members have a question? Representative McClain.
Thank you, Mr. Chairman, and thank you, Representative Gravely, for making sure that we did talk about that. I want to say thank you very much for getting back to me, too, because It was a concern that I did have, and you explained it very eloquently, so I definitely want to say thank you.
Absolutely.
And that's all I had, Mr. Chairman.
All right, thank you. Vice Chair Kirby.
Thank you, Mr. Chairman. Couple of things, and Commissioner Butler could probably, Chapter 9's not coming to me. The exception for Chapter 9,
Well, that's not actually dealing with the Department of Labor, so I don't think I need to be doing
Okay.
rules and regulations.
that's no wonder I couldn't think of what it said.
I think it's workers' comp.
Okay.
They probably wouldn't appreciate me doing the rules. for them.
No. We work hard on workers' comp. Keep out of that one. So, the second question I've got though, when we do criminal background checks at work, we look at the last 7 years. You can do 10 years. You can do forever. This doesn't have a limit on it. So we're saying we're going to look at somebody's entire life history.
Well, I mean, it's basically what this sets us up to do, and actually, this is not something that, in a simple world, we would just do this, and we could go to the FBI and we could get the federal background checks, whatnot. But they're requiring us to put this in state code in order to be able for us to ask them for this. As far back as it goes, I mean, obviously and I can tell you from our point of view how we hire. I mean, yes, we do want the full criminal history, but now just because you have a criminal record doesn't necessarily mean you're not going to get hired by us. We have hired people with criminal records in certain areas. However, there are some other things that we have to take into consideration, other rules and things, because we also deal with other federal agencies like Social Security Administration, things like that. Because we do have a lot of very sensitive information, and so therefore, if you have somebody who has, say, a history of identity fraud, you don't want them
Right.
handling Social Security numbers and things like that, obviously.
But if they had a conviction, let's say 20 years ago, is
Right.
that going to impact the decision, or is it just still case by case, or?
As long as they're honest in their job interview, we take a look at everybody on a case by case basis. I mean, matter of fact, I can only think of one person in the last 5 years that had a criminal background that applied for a job that didn't get the job, but it wasn't because of their criminal history, it's because they lied about it. I don't know why they had 5 charges and then they told us 3 and left out 2, and one of the 2 they left out was kidnapping. That's kind of important to know.
I understand.
Pull your mic closer.
Sorry.
All right. Do you wave? Okay. Representative Casey.
Thank you, Chairman. Just 2 quick questions. One, are you going to go back to existing employees and do this? And then 2, is there any kind of budgetary concerns for doing this?
It won't affect budget-wise. I mean, this is really no cost. This is just a requirement. I mean, we do certain type of background checks. This is just a better background check, more thorough when you're using the FBI. I mean, obviously, because their database is more, it's got data from other states. It's just better than what we're doing right now. So it's not going to impact that at all. I cannot answer. I'd have to talk to HR about whether or not we would go back. I would guess probably not. Because, I mean, the background checks we have now are pretty decent, but, if you're only getting Georgia, then that's not going to get you covered. And this is basically a new requirement by the feds saying you've got to put this in your code or you can no longer access our system. So this is kind of a new thing that they put on us. Matter of fact, they put on everybody. And a lot of the other agencies have already, come to General Assembly and got theirs changed, and us and Revenue are coming now.
Okay.
So
I appreciate
it's just
that.
one of those things that normally I don't think we should have to do this. I don't know why we can't just write up an MOU between us and the FBI and just do it, but for some reason they want it codified. I mean, and to ask me why they want it codified would be saying, why does the federal government do anything they do? And I really couldn't answer that.
Representative Marin.
Yes, thank you, Mr. Chair. Commissioner, does you do any background check and fingerprints as of now
Yeah,
for any employees?
yes.
Okay.
Yes.
And
We do background checks on every single employee that we hire, absolutely.
Okay.
Because we do have a lot of sensitive information. We have
Mhm.
requirements that are put on us by actually the Social Security Administration and also U.S. Department of Labor and others, where I mean, if you're gonna be sitting there and you're dealing with, I mean, you gotta understand, we know pretty much everything about an individual. I mean, probably just as much as, say, Department of Revenue does, because you have all your employment records, we know your employee, you know where you live. I mean, and a lot of people access our information also. And there's pretty stringent requirements for people to access our information. For example, we've had law enforcement. We've actually had this is kind of funny. We've actually had the FBI come to us and wanting our information. Now, do we require them to have fingerprint background check? No, we just kind of trust their FBI and they should know what they're looking for. And it's usually when they're trying to find somebody. I mean, sometimes it's because of a death. say they know where the person works and they have the name, but they can't, there's no identifiable address or whatever, they can actually ping our system and we can look at their employment information, and then we can see a home address, and then they can find where the person lived. So, I mean, there's all kind of ways that stuff's out there for. So, yes, you got to make sure that you're keeping the stuff safe, because it's not just, you're not just worried about hackers, obviously, and to hack our system would be almost impossible because it's 40 years old and nobody knows how to write the language anymore. But you also have to make sure that people are not selling that information, because you've seen cases and you read about it in paper where people working for different agencies across the nation, they'll write stuff down, keep stuff, and take it and sell it, to somebody and go, look, you can go out and you can get a credit card and that kind of thing. So you got to make sure that you're not putting people. You don't even want to tempt somebody. I mean, somebody may have done it in the past, maybe they're not going to do it again. They can work somewhere else in the department, but probably shouldn't tempt somebody who has a history of identity theft.
So follow up, so this will be for full-time employees, when you have part-time employees or temporary employees?
Anybody who has access to this, to the sensitive information has to have a
Gotcha.
background check.
Gotcha.
But
Thank
we
you.
pretty much background check most everybody.
All right, thank you, Commissioner.
All right, seeing no further questions, committee, I don't have a sign-up sheet. Has anybody signed up? Okay, no. So is there a pleasure of the committee? All right, we have a motion by Representative Marion, second. All in favor, say aye. All opposed, say no. It's carried. Congratulations. You may go see the Rules Chairman.
Thank you, sir.
Commissioner, don't go anywhere.
I thought you were going to say that.
Kirby, you're up.
All right, Chairman Workheiser, you may present House Bill 767. LC 363458.
Like the previous bill, this was brought to us by the commissioner, and actually to streamline the process, I think we have received a lot of comments that I think have taken this a little sideways, of some, I think, unintended thoughts. But the original thought of this was simply, and it's really just a couple of changes on lines 50 through 59, and that is to allow people who would normally be able to apply for unemployment to be able to do that online. And that is the
100% online.
yeah, 100% online instead of driving. And this seems to be the year of rural legislation, so this would certainly help people in the rural areas where they're not having to drive. That was the premise of the bill. There was no underlying areas focused on that, and so we'll go with questions, I guess.
All right. Commissioner, I'm going to ask this question I already know the answer to, having done HR in multiple states. This is not uncommon for many, many states in our country just to have this access for unemployment online, is it?
Yeah, right now, currently how our system is set up, if you apply for unemployment, if it's at some point in the first few weeks, you have to show up physically at a career center and present your ID, affidavit, et cetera, to prove that you are who you say you are. But now with the advent of the secure ID, we would like to make it convenient for individuals who have that ID to not have to drive in. Now, there's nothing this bill does that's going to change what's already in existing code that requires us to have to do this anyway. But it would be really great for those that have gotten their new driver's license not to actually have to drive in. So really, this is a convenience for the citizens of Georgia who have the secure ID. I can't speak to other forms of ID because we can't cover that with this, because we have to make sure, because this actually speaks to some sections of Georgia law that have to do with some stuff that was passed years ago about public benefit and proving that you are who you are. But now with the Real ID, and some other agencies have done the same thing, and it's just a convenience, because like most states, when you apply for unemployment benefits online, you don't have to show up at a career center. Matter of fact, there are some states that have almost done away with a lot of their UI physical locations because they have gone totally online. Obviously, we're not that way here in Georgia, but we'd also, like to, for those that do have the Real ID, we can ping that driver's license. Worst case scenario, they send us an image of it. We know you are who you are. Then when we do our investigations to make sure you've made your wages, whatnot, you get your unemployment. It is not to there's actually was some confusion from USDOL. They thought we were going to say that only the people who have a Georgia driver's license, they're the only ones that can get. And we're like, no, and we had to show them the reference in the code sections, what we're talking about, and they go, oh, okay, never mind. You know, it's kind of one of those kind of things. You know, a 2-page letter for no reason. So, but that's all we're trying to do, is make it easier, especially for rural Georgia. You know, there are some career centers where an individual may have to drive an hour, 20 hour and a half to get to the closest career center. And if you've lost your job, that's a lot of gas just to go through there. And that's money you could be using to buy groceries. There's no sense in you having to do that. And, you know, this is, we're just trying to figure out a way to not only help Georgia citizens save money, but it also be a money saver for the department. And we need to save all the money we can right now, because we are, everybody else has got plenty of money. We actually have a whole lot less money in the department.
18, is that Representative Park?
Thank you, Chairman. Chairman Werkheiser, Commissioner, thank you for being here. Thank you for the for bringing this bill, as well as for the intent of it. I was wondering if on lines 52 to 53, you'd be open to a friendly amendment to change verifiable and unexpired driver's license or identification card to a secure and verifiable document under OCGA 5036-2, because that would include or permit verification to be done with an unexpired United States military ID. Is there any concerns that by specifying that it's just a driver's license or a state ID, that with a military ID, someone otherwise eligible will not be able to receive benefits?
Are you saying an expired military ID?
An
or
unexpired.
Unexpired
Yes,
military ID. I have to look at my lawyer, because he's one that knows the code sections better than I do, and maybe, Wow. So, I guess I would be fine with that, yes.
Does that military, I'm not that familiar with them, does that gonna pin them down to somebody in Georgia, or could it be somebody
Well,
who?
First of all, let's make something quite clear. It would be kind of odd for somebody in the military to be applying for unemployment, because you would be working.
So, for example, if someone does not have an unexpired driver's license or state ID, but they have, just to make sure that this does not exclude anyone who would otherwise be eligible again.
Could we be on the safe side if you want to amend it, just to add that to that, and/or another, instead of striking the other one, because I would feel a little bit uneasy if you struck the language in there, because that may kill the intent. But to add what you're asking for is fine. However, it's very rare that we ever get somebody, I can't even think of a case where somebody in the military that would apply for unemployment.
So under the definition of secure and verifiable document, OCGA 50-36-2, it includes, or your lawyer maybe.
The original intent was to make it so that we could do this electronically.
Yes, sir.
And to use the documents that we talked to Legislative Council about, as far as saying that these are verifiable. To get a driver's license or a Georgia ID, you meet all the code requirements right now. I understand what you're saying. I'm just not sure how, if it was electronic, we could ping the Department of Defense to get it verified. That's the reason. I mean, this is strictly them putting in the information, and the Department of Driver Services coming back and saying, yes, that is an active license, or no, it's not. If it's not, then we'll tell them, you need to go see DDS, just like we do with Social Security numbers.
Yeah, because, I mean, make sure I'm clear. I mean, this does not prohibit anybody from getting unemployment benefits at all. We can't. Matter of fact, I know that I got actually a very unfriendly phone call 1 year about this. I think this is not the first time we visited this. Or somebody thought that we were trying to, keep this one from getting unemployment, that one, whatnot. I'm like, look, here's the deal. If it doesn't, and matter of fact, it comes down to this, and I'll go ahead and put this out there. Even if, let's say, you're here in Georgia and you're not a legal resident of the United States, however, you're being allowed to stay in the United States, you're being permitted by the federal government, and you are being permitted to work, and you've been given an identification number, and an employer is paying unemployment taxes on you, and you get laid off, you're eligible for unemployment benefits. It doesn't matter. And I know in the past people says, well, you're giving unemployment to people who are not here legally. I went, well, they're being allowed to work legally, and therefore we have to give it to them if somebody's paying taxes on them, and they get laid off for a reason of no fault of their own. So this has nothing to do with that either. So all this is really simply, we're just trying to help some folks out not to have to drive to a career center if they don't have to. If you've been laid off, no fault of your own, you don't have to drive in and go, look, hey, it's me, okay? And then drive all the way back for that,
And-
okay?
And thank you, Commissioner. And by no means would I want to undermine the effect that bill would have by trying to broaden the definition of the type of secure and verifiable documents that would be permitted. So if that were the case, if the effect of trying to do so would undermine the intent of allowing someone to more easily obtain unemployment benefits online, I'd take that, remove that amendment.
Well, and I definitely appreciate what you're saying, because my son served and did 2 tours in Iraq, and so I'm very much have a soft spot in my heart for anybody in the military or veterans.
Likewise.
But yes, I mean, I think the attorney, I didn't think about that. I don't think the Department of Defense would probably allow us to ping their system to see. And we're having hard enough time with the FBI. I can't imagine what DOD would be like.
Okay. Thank you, Commissioner. Thank you.
Representative McLean.
Thank you, Mr. Chairman, and thank you, Commissioner, too. I do understand that the intent, and the only thing I want to make sure that I understand before I vote, the secure and verifiable documents under OCGA 50-36-2, all of that is still, that was sent out by the Attorney General, that is still good.
Yes,
And
yes.
and that's all I want.
Yeah, no, it didn't change any of that. It just allows you to say, all right, this driver's license, the secure ID driver license, it represents that. And so we don't have to, and as long as we can ping it and go back, yes, that's that person, they do exist. Because, you know, we do more than that, you know, as you know, very well know. We have to turn around and then we talk to the employer to see, you know, what the situation was. They laid off, yes, there is. Been a layoff, this person, and they're identified, and then they go through there. Because, as you well know, there's also been cases of where people have stolen people's identity and tried to claim unemployment before. And so, I mean, we're very careful about it, but, you know, we feel very confident this is a good way not only to save people some time and give it convenience, but also to keep us on that secure line to make sure we're, you know, only giving people benefits who are supposed to be getting benefits and keeping fraud out of the system.
And I just think that was just follow up, Mr. Chairman, I just wanted to make sure that the secure and verifiable document that the Attorney General sent out is still good.
Yes.
Thank you.
All right, Representative Marin.
Yes, Commissioner, real quick, states that have gone without, getting rid of the centers, 2 or 3 states that you can tell us. And the follow-up question is Georgia going into that direction anytime soon? You mentioned that there's some states that centers are being closed because everything has been done now electronically. So my question is, do you have a couple states that have done that? And is Georgia looking into that direction anytime soon?
Well, I can tell you the last several years, a lot of states have closed a lot of their career centers, and, you know, some of that has to do with, you know, more things going online, but even more so, a lot of it has to do with the fact of a decrease in funding. And I know this seems kind of weird because we're, you know, all this money is everywhere. Everybody's, oh, everybody's good, everybody got plenty of money. Well, for Department of Labor's, and not just in Georgia, but across the nation, it's actually the reverse for us. Because the better the economy is, the less money they put into our funding, because they think, well, you don't need as much money because the economy's better. And so you get into a question of funding. And so, I mean, and we've downsized here in Georgia. We don't have near as many career centers as we had 7 years ago. And we're probably going to, not probably, we're going to see, unless, you know, some money falls out of the sky, we're going to see some closures again this year. And sometimes it's a plain, just a straight out closure. Sometimes we're combining with another office of maybe somebody else, you know, maybe, for example, a local workforce board. We may move some of our people in their office. Matter of fact, we did that in Eastman here recently. We combined with a local workforce board. And we're going to do that in a few other locations. So, yeah, you're going to see fewer locations, and most of that's going to be tied to funding more than it is what we're talking about here, though.
Thank you.
All right, nobody else up here has, we got a couple people though that want to speak.
Chairman.
That's 789, not on this bill. All right,
It's proper time, Mr. Chairman, I'd like to make a motion.
all right, we'll let you, Representative McLean, make your motion.
Proper time, I'd like to make a motion to approve.
All right, we got a motion due pass, second from Representative Marin. All those in favor of due pass of House Bill 767, say aye. Aye. Opposed? Motion passes. Thank you.
Thank you. Thank you.
are you all leaving, or can you all stay for 789? I think there may be some questions for you two. Are you all?
If you need me to stay, I will stay.
Well, I definitely like for you to stay.
Probably wouldn't hurt.
Thank you.
Are y'all hearing that bill next?
No, actually,
I don't know when we're doing it, Mr.
I'm gonna
Commissioner.
see if I can go get a little drink of water.
okay, go ahead.
Talking, I'm a little parched.
Because
Thank
we're gonna go ahead and do Representative Buzz Brockway on. I'm sorry. Well, go ahead. Let's go. House Resolution 744, and then we'll do House Bill 800. So, Mr. Brockway, go ahead.
Great. Thank you, Mr. Chairman and members of the committee. Want to bring to you House Resolution 744. What this is attempting to do is deal with, well, quite frankly, a commission in state Georgia that's not doing what the law requires it to do. And since we can't pass a law instructing people to follow the law, I've brought this resolution to hopefully to shine attention on this. So what I've discovered, I'm in my 8th year in the legislature, and every year we learn something new. And last year I learned that there was an entity called the Georgia Occupational Regulatory Review Council. And it has two jobs. First of all, when a member of the legislature proposes a new professional license, this board gets together and reviews that and determines, makes a recommendation to the legislature of whether or not that profession needs to be licensed. And the second thing it's supposed to do, and this was a law that was passed in 2010, this board was given the additional authority to receive reports once every 7 years from each of Georgia's 41 licensing boards on why that profession needs to continue to be licensed. And so I wanted to see what those reports were. Were they getting the reports from the various boards to see why do we need to continue to license that particular profession? What are the regulations on each of those professions? Are we regulating these professions at the right amount of regulation? Because if we're regulating them too much, then we're freezing people out of those jobs. If we're regulating it not enough, then we're not doing our job in protecting the public from harm and fraud. And so I contacted them and asked them, where can I find those reports? And they said, well, we don't do that. And I said, why not? They said, well, we don't have the money. And I said, well, what money do you need? We don't know. Have you made a request to the Office of Planning and Budget to get this money? No. I said, well, honestly, I don't think that's acceptable. The law requires you to do this. And so that's where this comes from. Now, why is this important, and what do I hope to accomplish out of this? Professional licensing, in the time that I've been here, we've created several new professional licenses. I voted against every one of them because I didn't think that there were professions that needed to have a board created and have the Secretary of State manage that and have taxpayer dollars spent to oversee that. I felt that those professions could police themselves just fine without the government getting involved. And what I've seen is a trend toward licensing more professions. We see this across the country. We've also seen a trend in raising the requirements for each profession. And just to give you an example, in the state of Georgia, EMTs, emergency medical technicians, require, in order to meet the requirements to obtain an EMT license in Georgia, you need to perform 110 hours, clock hours of training. Now that sounds reasonable. If you want to be a barber in the state of Georgia, you need to earn 1,500 hours of clock training. Now, I'm not arguing that EMTs need more regulation. What I'm arguing is that perhaps 1,500 hours for a barber is too much, and perhaps 1,000 hours that Georgia requires right now for a makeup artist is too much. And who this hurts, honestly, are people on the lower end of our economic strata who are trying to get into a profession to earn money to support themselves and their family. And if you want to be a barber in Georgia and you have to go get 1,500 hours worth of training, that's I think an unnecessary burden. So the purpose of this, of giving the Georgia Occupation Regulatory Review Council this authority to receive these reports back from each of these licensing boards, is to take a look at this and to examine what the regulations are of each one of these licensing boards, and then provide a report to us in the legislature where we can look at it and say, is this proper? Do we really need 1,500 hours of training to become a barber in the state of Georgia, or is that too much? Do we really need 1,000 hours of training to become a makeup artist in the state of Georgia? And so, since this entity is not doing its job,
then we're not receiving as legislators that information, and it makes it harder for us to do our job. So what I hope to accomplish out of this, and why I'm asking this committee to move this forward onto rules, and so we and possibly consider this on the House floor, is to shine a light on this and to draw attention to this, so that the members of this board will get together and do what the law requires them to do. If they need money, well, then let's make a request to the Office of Planning and Budget, and let's get them that money so they can do their jobs. I don't know that they need much money, because the members of the board are all already permanent employees of the state government. They're already getting paid. So if there's other roadblocks into them doing this, then let's figure out what those are, and let's eliminate them, and let's let them do that job, so that we as legislators can be armed with this information and know that we are not over-regulating these professions in the state of Georgia. So, Mr. Chairman, that is the resolution, and that's why I brought it to you, and I would ask for your support, and I'll be happy to answer any questions.
All right, 26, who's that? Is that Bonner? All right, Representative Bonner.
Representative.
So exactly what is the composition of this council?
The members are the Controller General and his designee, the Secretary of State and his or her designee, Commissioner of Public Health, Director of Office of Planning and Budget, and all these or their designees apply to all that. Commissioner of Natural Resources, State Revenue Commissioner, Commissioner of Agriculture. And if they're examining, those are the permanent members of the board of the council. If they're examining a new proposed license that one of us in the legislature proposes, then a member of the House and a member of the Senate from the appropriate committees are assigned to that as well, to participate in that evaluation as to whether we need that new license.
And follow-up question, Mr. Chairman. Has this council, is there a history of this council ever meeting, or a history of any
They did.
activity?
They have produced the reports when we are proposing a new license. There was one report submitted last year when we voted on Representative Petrie's bill about licensing durable medical device manufacturers. So they have produced those reports in the past, but they have not. They were given this authority that I'm talking about here in 2010. I can't find any evidence that they've ever done one of those periodic reviews of currently existing professional licensing boards. Thank you for the questions.
Thank you, Mr. Chairman.
Anybody else? And I don't see anybody signed up to speak to this, so we can ask for the pleasure of the committee. Okay, we have a motion by Mr. Kirby for due pass. Second by Mr. Bonner. All those in favor say aye. Aye. All those opposed say no. Congratulations, Representative.
Thank you, Chairman and Committee. I appreciate it.
Thank you.
Okay, Representative Bonner, House Bill 800.
Thank you, Mr. Chairman, members of the committee. I bring today House Bill 800, and I'm working off of LC 363480. House Bill 800 does away with the offices of Director Emeritus and Administrative Law Judge Emeritus positions for anyone in the future who is not in the office as of June 30th of 2018. These positions were created at a time when retirement, prior to the state of Georgia providing any type of employee retirement system, so that those directors and judges of the board would have some type of retirement benefit, and this is no longer necessary. So this is a cost-saving move. It does not impact anyone that is currently in the queue, but only those that would be hired after June of 2018. And with that, I'll stand for any questions.
Are there any questions from the committee? And I don't see anyone signed up. The pleasure of the committee. Chairman Shaw, do pass. Second? Second from Representative Barron. All in favor say aye. Aye. All opposed say no. Congratulations.
Thank you, Mr.
You may
Chairman.
now go see rules. Next we have House Bill 789 from Representative Fleming. You may do so.
No, you don't want to look at me. Mr. Chairman, thank you, members of the committee. I bring to you today House Bill 789. And, Mr. Chairman, if I may ask Ms. Gina Fornaria if she would come up to the podium and get ready, because at the appropriate time, I'm going to ask if she can give us some additional information about the bill, and she'll introduce herself. But, Mr. Chairman, thank you. House Bill 789 is a bill which attempts to clarify and codify our independent contractor law in the state of Georgia, such that we can attract and seek expansion of some internet-based companies that are already coming to Georgia. And Handy, the company that is here today that brought this to my attention, is one of the ones that we're trying to get to expand in Georgia. Mr. Chairman, as members of the committee know, when you work with somebody or for somebody, you are classified as an employee, or you are classified quite often as an independent contractor. And the difference between the two is very important, because if you are an employee, as the businessmen on this panel know, you have to take out taxes on that person, withholdings, they have to be covered by workers' comp law. However, if you're an independent contractor under the law, those certain provisions of the law don't apply to you. For example, as an attorney, if you hire me to help you, you don't have to take out taxes on me, and you don't have to make me covered under your workers' comp, because even though I'm working for you, I am not your employee, I'm an independent contractor. That distinction exists in Georgia law, has been around forever, exists in every state. However, in the state of Georgia, what independent contractor is not defined succinctly in our code. It is, however, defined through a lot of case law. Through the years, our courts have fashioned that. The reason this bill is before you today is not to at all change Georgia law on this difference between independent contractor and employee, but simply codify it and put it inside our code, rather than a business coming to Georgia trying to figure out what our law is, having to look through extensive case law to figure that out. We do this, as you know, quite often here. We take law that is case law, and we codify it by putting it in our code. The company that was brought to my attention that was asking us to clarify this in Georgia I'll call it a technology internet-based company, so to speak. I don't get those terms well. My 16-year-old does a much better job with them. But I use the analogy of Uber. We're all familiar with Uber. I hit the Uber app on my phone. The Uber company connects me with a person that is one of their approved drivers. They come and they take me to a different location in Atlanta. However, there's also a company out there based in New York called Handy. And they call themselves Handy because I think it's short for the term handyman. How often are you around the house and you want somebody to help you repair a shelf? Somebody to fix a floorboard that's messed up? And my wife does not allow me to do such things because I mess them up. So Handy is an app on your phone. You hit the app. This company helps hook you up with somebody who is a handyman that they have been approved to work with them, and comes to your home after the negotiations of the price and exactly what you want them to do, and they will help you repair whatever's wrong. They are already operating in Georgia, but they would like to expand greatly, and one thing that they asked is, could we codify our law dealing with independent contractors so that there would be no question that the people that work for them are indeed independent contractors, work with them rather, and not employees. So the purpose of the bill in front of you is not to change Georgia law, but to simply codify that distinction and make it very clear to them or any other company that wants to come here that's internet-based like they are, that our independent contractor law is clear. Mr. Chairman, of course, at your discretion, but if you would allow me, I would like to introduce to you Gina Fornario, and I want to get that right. She is General Counsel for Handy, flew down from New York just to be with us today to introduce herself and her company to us and make a few comments and clarify anything that I messed up about what we're trying to do. Is that okay, Mr. Chairman?
Yes, go ahead, Gina.
Good afternoon. Thank you. It's great to be here, and snow couldn't keep me away. So as for the introduction, that's right. Handy is the country's leading online platform for connecting individuals looking for household services with such as home cleaning or plumbing, with independent service professionals who provide those services. So what used to take days or weeks to find somebody that could come and help you with a household problem now takes 60 seconds through our technology app. And we've been operating in Georgia since October 2013. We have 17,000 customers who've used the platform, approximately 3,400 independent service providers who've used it to claim jobs and could be connected with people looking for services. And we've performed about 70,000 jobs. So one of the things as we look to further expand is just clarification to be codified into law of case laws that exists. And so that's why we're here today and in support of House Bill 789. Again, it's not to change any law that exists, but just codify and make clear the law that is currently as it stands today. And so, again, just this bill as it stands provides clarification that there's clear rules to follow. I'm happy to entertain any questions on the bill from the committee or on any of the particular issues. So,
Representative Carpenter.
Thank you, Chairman. Just real quick, talk me through the payment process on this. So does the customer pay you and then you pay the independent contractor, if you will, or do they pay the independent contractor directly?
so we use a third-party payment provider just to facilitate the service. We do not personally collect the money. It's a payment provider called Stripe. So the person looking to purchase the service will input their payment information. That gets transmitted to Stripe, and then once somebody, if an independent service provider decides to take the job, the payment gets remitted to them through Stripe.
Okay, and then maybe they just pay you a percentage or whatnot to, is that, or do they charge them a listing fee?
In essence, correct.
Okay, so in theory, you're not even receiving payment for them. You're just providing them a third party.
That's correct.
So no problem. Thank you.
Yeah, Mr. Chairman, and not to interrupt, but if I could be to make sure we all know we're working off of LC 3635 43S.
That's correct. All right, 26, is that Hill or Bonner? All right, Representative Bonner, go ahead.
Just a question, on line 21, this does not include transporting freight, containers, boxes for compensation. Is there a particular reason that is not included?
I believe that there is. I do not know the reason behind that at this juncture. I believe that it's because it's codified in some other area of the law as to the status of people that perform those services, but I'd have to double check that and get back to you.
Okay.
Okay, Chairman Shaw.
Thank you, Mr. Chairman. Thank you for being here. So we referenced Uber, being a similar platform for when you need a ride, but when you need a handyman, we've had to work on some issues with the Uber and Lyft apps here in terms of ensuring that there's adequate liability protection for those passengers and customers in that platform. So in this arrangement, even though these are independent contractors, my question just is concerning if this handyman, he or she, falls off the roof, gets hurt, are they required to provide the workers' comp certificate of coverage to you all? Are they licensed, insured, so forth?
Sure. So pursuant to our independent services agreement that they would enter into, they're required to carry all such insurance and all such licenses to cover them in such instance.
Okay.
And
Thank you.
If I could follow up on that, so let's say a plumber comes in and they create a flood, their insurance, they would have to be insured before signing up for your app.
Correct.
Okay.
They would contractually agree with us to carry that. Yes.
Is there something that would hold the property owner harmless in the event that there is major property damage, that's done where the handyman might be liable?
I believe that there is in the service professional agreement a provision as such because their insurance would then kick in that instance, but I can double check that as well.
Okay. My fear, I think there's just, when you're dealing with companies such as yours and it's real-time electronic, I would just assume that all that would be taken care of. We just want to make sure that, Lord knows if the insurance had canceled the day before, that y'all have ways
Sure.
to know that you would have been notified prior to
Right.
that ever taking place, so you could have taken corrective action before it's too late.
Right, I understand. We also so the company in itself, although we recognize these are independent contractors that
Right.
carry their own insurance, we are also, as a company, obviously insured, and God forbid any such terrible situation like that happened. There's always, every booking has a backup.
Sure. Okay, great. Thank you.
You're welcome.
Okay, Chairman Pruitt.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I think my button's already matched. I don't know if I'm on or
There,
whether or
try
not.
that.
There we go. I'm sorry. I do apologize, but I have not really dug into this bill, and this is something that I'm a little familiar with from being in the contracting business. But so the questions I'm going to ask, I'm sure, are located in the bill somewhere. But one of my concerns is that my understanding is there's no liability, so it's just a pass-through. And is that correct? So you're more of a marketing company, and all the liability passes through to the contractor?
Correct.
Okay. And what about their taxes and things like that? If they don't pay their taxes, all that is just, that's on them? Is that
Correct. Yes, that is spelled out in our agreement with the provider.
How do you go about, and I'm asking this for a particular reason, not trying to dive into your business, but how do you go about selecting and approving these contracts?
No, that's a great question. So they will come and self-certify. So depending whether they want to provide cleaning services, home improvement services, they will come through a process where they will self-certify that this is their level of experience, what jobs they're able to perform, and then before anybody gets activated for the platform, they actually have to go through a 4-step kind of process just to confirm identity, make sure they are who they say they are, a background check, in addition to the self-assessment. So there's a variety of, and then they have to have their bank information verified by the third-party provider, Stripe.
So you ensure that they are licensed and have a license number in the area where they want to work, is that correct?
If it's an area that requires a license in the state, then yeah, we ask for that they guarantee that in the service professional agreement, that they have the necessary licenses.
Okay, you say they guaranteed it. They don't have to show you proof that they're licensed or have a license number, or?
It depends on the service they're providing, and we do it on a state-by-state basis because each state has different.
Would there be, I'm just hypothetical question, but would there be any way that a company, I'm sorry, Mr. Chairman,
No,
I've
go
got
ahead.
multiple questions, but if I stop between everyone, I will if you ask me.
No, go ahead. No.
Okay, thank you. If they, in the event that someone decides they're in this area and they want to be on your list multiple times, could they have different companies licensed and things like that, so they can have multiple listings or anything? And I'm just saying that I really don't know how it works. I'll be honest with you.
Oh, sure.
So
I think, are you asking, can they, if they have like Bob's Plumbing, could they have another? So
yeah.
the way that we have the people activated based on their individual identity and name, so they would only have that once, but as they set up their profile, so they get to kind of set up their little area and advertise what they do, their background, then they could put in their affiliate name. But in terms of actually getting approved, we would have a blocker, so they couldn't set up duplicate accounts.
Under the same name or the same license number.
License number,
Right.
Social Security.
Okay.
Because we perform an identity check, right? So that is something that we would be working to block.
One last question for the moment. What really is the problem? I don't really understand what the issue is.
If I may, Mr. Chairman, the issue is this. If you want to come to Georgia and find out, for example, what the qualifications are to run for the House of Representatives, I can point you to those code books and I can tell you exactly where it is and you can read it. If, however, you want to come to Georgia and be an internet-based company like this and know what an independent contractor law, it is not in our code books. You have to go through a series of court cases. Now, you can come hire me to do that, Jimmy. I'll charge you a fair fee. But
Sure you
actually,
will.
I'm putting myself out of work. If we codify this and put it in the case law, it is much more simpler for anyone to know exactly what the law is. And once again, we're not changing Georgia law. Georgia law, as you know, can exist in two places. It can exist in all the court cases that are handed down through the years, or it can exist in the code that you and I change regularly on the floor of the House. So what we're doing is we're taking what an independent contractor is out of the case law and
I
putting it over in
got
the
to
code.
interrupt. I'm sorry, but this is not
Yeah.
about changing contractor law. This is about
No.
this is marketing. So, do you have a problem with your company as far as marketing? Because I know what a contractor is, and I know what you have to qualify to be a contractor.
I mean, there's certain things you have to do, even as a subcontractor. You have to have the right to hire and fire and run your own company, make your own decisions and things like that. But why, I don't quite understand what we're doing for, I'm sorry, I'm not trying to be, I'm trying to be sincere. I don't understand why we have a problem with the marketing, because this is about your business and the marketing and not about contracting.
Right. So states like California might disagree. They find that the law on this platform usage is a little ambiguous, and that's what we're trying to solve here.
One more time, I'm gonna say, I understand, but how is it hindering you from doing business? That's what I want to know.
Oh, it's in terms of hindering us from doing business, we always want to operate in a clear kind of fashion and grow and comply with law. And as it is currently drafted, it's not clear, it's not codified anywhere. And so in terms of growth, we can do that, but it does hinder and have a chilling effect, this area of uncertainty.
May I take a run at this? So just to look at the other side from a consumer point, and correct me if I'm wrong, and again, this is one of the things this committee's gonna work on, because 4 years ago, the Senate had a study committee that nothing was ever done with codifying the independent contractor versus employees. But from let's say I'm gonna hire a plumber, it would clarify if I knew who a contractor was, as opposed to if I hired them, it relieves me of knowing that that I don't have to withhold taxes on them, or that I'm not treating them as an employee, that I am treating them as an independent contractor. Would that be fair?
Mr. Chairman, if I could interrupt, I worked on that bill. And that issue was the difference between the definition of a contractor and a subcontractor. But this is a marketing issue, unless somebody can tell me how it's not. I don't understand that she is not, or these Handy, which I like that name, they're not in the contracting business.
They are in the business of hiring independent contractors.
That's correct.
And when they hire an independent contractor, they have to go to several cases in Georgia case law to know what independent contractor law is in Georgia. We're actually doing this because they brought it to our attention, but I would submit to you, by taking multiple pages out of case law books and putting it in a more coherent, logical, easily accessed place in our code book, we are actually going to make Georgia an even better place to do business, because one does not have to decipher through several cases what an independent contractor in this situation is. One simply looks in this code section. So although we are passing a new law, we are not changing Georgia law. We're simply taking it from cases and putting it into the code section.
Mr. Chairman, one more comment. And Representative is my friend, and I respect him very much, but he actually mentioned the word hire a contractor. You don't hire a contractor, do you?
We are an internet platform, just to be precise. We are an internet platform that allows people to market their service to others.
Right.
So yeah, no, we are not hiring an independent contractor in that fashion, but we are allowing them to use our platform too.
Okay, we're gonna keep moving. Next I had, if I remember my order, Representative McLean.
Thank you very much, Mr. Chairman. And I guess it was one of the reasons that I asked the commissioner to stay, because I wanted him to hear exactly what was going on with independent contractors and of that sort. Because my only concern is we, he's already overburdened with what he's dealing with as we are right now, and to create another entity or to create something different, I just don't know how it could be policed. We talked about liability issues. We talked about background issues. But I guess I'll go to my friend Representative Pruitt. My only concern was who's liable if, you send someone over and my house get flooded, and, so are you saying the person that came over was liable, or Handy is liable?
No, the independent contractor is an independent business. They would be liable for any wrongdoing.
So when he comes over, I guess I'll go to my other friend. So when he comes over, he'll show me his license that he's bonded. I mean, other than me going through the yellow pages and seeing somebody saying I'm bonded and all of that stuff. So I'm just.
So they're not our employees, so we can't control, and we don't control what they do not show. But presumably you could ask for that information. I know that people that have used our platform have in fact asked for such information from independent contractors when they arrive.
So you feel that the fee that they're paying, they're not your employee, they're independent contractors. So I'm just trying to figure out
Sure.
where does employee come in and independent contractor, because if you're getting a fee, that means that they're either employed by you or.
So we are not, in term, when you say we're getting a fee, so think about any.
Like Uber and Lyft and those.
Correct, or a platform where you would go to advertise your services. So Yelp, if you were to advertise your business, you pay Yelp a fee. And then you put your business up, people can go to your site, check out reviews on you, book through Yelp or OpenTable, for example. Same thing, I don't know if you're familiar with that app. So you can go book a restaurant, you see the reviews, pick a time. So we function in a similar format in that we're technology. Somebody would pay us a fee, they want to advertise their service, market themselves, put it out there, and then they are getting kind of referrals and connections through other people that come through our site.
Mr. Commissioner, I'm sorry, I just want to ask one question of you. I mean, since you are here, the marketplace platform and independent contractor, my question to you is that going to put a burden on your department where you already have a burden to not?
Might as well come up to the mic since we're being filmed. Either one.
This is one of these issues, I think it pops up about every year. It would be really good if we could at some point get some type of clarity, because there are some cases to where we do have to depend on case law to determine, whether or not somebody's independent contractor, whether or not, they're an employee. Sometimes it's clear cut. Now, I was sitting there thinking about some of these platforms, like, for example, I actually used, I can't think of the name of the service, one time to find somebody to do yard work, and you go on there and it gives you different ones, and you go, hey, I've got that yard on so-and-so street, and you guys give me bids, and I'm assuming those people pay money, but obviously those people I would not think would be employees. But anytime you guys, when I say the General Assembly, if there was, because we don't really have anything in code right now, okay, but once you do put it in code, then it's there. And then if there's a set, you have to be, only thing I would caution, be very careful what you do put in code. Make sure it's well drawn out, and there is some flexibility for a little bit of interpretation, because there's no way, in my opinion, in my learned opinion, after doing this for this many years, that you're going to be able to cover every single situation and nail it down, whether or not it's independent contractor versus employee. There's always a little bit of, iffiness to it. Of course, I've always looked at it from the point of view is, if you go to work for somebody, no matter how they're doing it, if they're telling you where to go, when to go, how to do it, you're an employee. If a guy's just got a list of jobs on the board and you can come by anytime you want to and you can pick one, you can go do it, and you're working on your own pace, using your own stuff, whatever that is, then you're an independent contractor. But the thing is, a lot of people take that same thing, and we do see abuses, all the time. We've gotten some great heads up from some of your friends, Representative, that have told us about some abuses, and we'll go investigate it, sure enough. It's like, I know one guy that did masonry work at the airport, and he had, I think, about 70 people working for him, laying brick, and he was trying to say that all 70 bricklayers are independent contractors. That obviously was not true. There's no way that he had 70 independent contractors. How in the world could you ever get any brick laid if all of them are working independently? There's no way. So you do see abuses. But, I would just caution, anything that you do, and then, we did have this run by us, and we looked at it. We didn't see anything that would cause us any additional cost or any additional personnel with it. We did, get some advice about what you might want to, check with workers' comp and a few others and things like that. But, and make sure we didn't see anything that would run afoul with us. But that's about as far as we got with it.
Okay.
Thank you.
All right, Representative Park.
Thank you, Chairman. Thank you for being here. Commissioner, I did have one quick question, sorry, if you don't mind. So,
Quite popular today, whether that's good or bad.
For the purposes of having clarity in the marketplace and certainty for businesses, would it not then just be better, in your learned opinion, to have a broad definition of both what an employee is versus an independent contractor, rather than breaking it down for a specific industry such as this market at place? Or does it help to have this type of specification?
Well, I can tell you just in this certain case that we're talking about, I mean, I don't really have a problem with this. I think it's spelled out pretty clear. I actually understand the concept because I have used something similar to it. You know, it'd be different if they were all wearing the same uniform and they're working, you know, it's kind of whatever, then it's one thing. But if you're just placing an ad and they're running the payment through there or whatnot, I can see where that kind of comes into. Because it's actually a cost savings for the, I guess you want to call it the independent contractor, the person who's doing like the physical work, because you don't have to go and set up an account for Visa, MasterCard, and those things get expensive, whatnot. I mean, PayPal charges, I know, whatever percentage it is, whatnot. You know, what I would say going forward, you know, I think maybe at some point you ought to look at, you know, some other areas too, but there's nothing, I mean, this is something right here, I mean, if it's needed to get some clarity and it has it actually in law, so there's no misinterpretation, I mean, this to me, it sounds right when you read it, the way I read it, how it's on here. If you're just using this thing to basically allow people to advertise, and then they can look to see who's asking for bids and whatnot, and you can go do a plumbing job or electrical job, whatever, as long as they're credentialed the proper way. I mean, I don't really see this being an issue when it comes to employee versus contractor. I would have an issue with it if it was saying, okay, we're going to call them independent contractors. However, we're going to be telling them where to go, when to go. And oh, by the way, you have to wear our uniform. You have to, you know, drive a truck that's got our stuff on it. Then I would be able to tell you, no, this is not good. This is taking advantage of somebody. But if you're allowing somebody, you know, I look at it from a small business person. And, you know, and I come from a family that I got electricians, I got carpenters, I got plumbers. And if you're out, especially out in rural Georgia or somewhere semi-rural, and you want to be able to advertise and people can go on and find you with an app or whatever, I mean, you know, and it is what it is.
Thank you, Commissioner. I did have a few more questions. Thank you for being here again
I'll
from New York.
hang out a little bit longer just in case.
Thank you, sir. So just to get a better understanding of the app itself, so you said that there's a self-certification process. Does that include, you know, criminal background checks, especially as that's one of the issues that we were discussing earlier? Because I think one of the concerns I'd have, especially if someone is coming into my house to fix something under the guise of this app, and you know, we don't know whether or not this person has a criminal past of, you know, stealing or what have you. Who then takes responsibility for that?
So we do perform background checks and conduct an extensive vetting process. If there is an issue that arises, we will handle those on a case-by-case basis and determine the best course of action.
In regards to payment, sorry, Chairman, if I may. In regards to payment, is the customer paying the app, and are y'all then paying the contractor?
So the customer is paying a third-party payment processor, as the commissioner noted, that those kind of tend to be a little expensive, and we help, as our platform, this is like the value add that we can facilitate this for people. So they actually pay Stripe, a third-party payment processor, and Stripe then remits the proceeds to the pro directly. So we're not in the middle of that transaction.
Okay. My last question, I think this would be to the author of the bill as well, would be whether or not you'd be open to some friendly amendments to just specify the independent contractor nature of the relationship.
I would be open to friendly amendments, but I don't think yours are friendly.
Well, an amendment perhaps that we could discuss.
Can we, let's address amendments later. Let's get the questions out of the way.
Thank you.
Okay? Okay, Vice Chair Kirby.
Thank you, Mr. Chairman. And kind of listening to some of this conversation up here, and especially Representative Pruitt, if you look on line 17.3A, it says marketplace contractor, and I think sometimes we're getting hung up on that word contractor.
Yep.
In my mind, I read that as marketplace facilitator, because that's what they're doing. They're facilitating this between two separate parties as opposed to a contractor that we think in the building industry. And I think anytime you then when you go through the rest of the bill thinking they're just facilitating this arrangement, it makes a lot more sense to their business model. Is that accurate?
Yes.
Thank you.
Okay, I'm trying to catch these as they popped up. Representative Marin.
Yeah, thank you, Mr. Chairman, and I think we're creating this for a new industry. And there's many questions going back and forth from the committee, and thank you for being here. And I'd like to do a motion that maybe we can send this to a subcommittee and we can process it a little bit more.
All right, we'll take motions and amendments at the end. He waives. What about Hill? You have a question?
Thank you, Chairman. I think my questions have been answered. I think this was just an attempt to have a better understanding and clarification of what a contractor is versus an employee. I think that was the attempt. And my other question or concern was the legitimacy of the contractor once he's out there open to our public, and how safe is it, and because we don't want to have someone who's going to cause harm to the public. And you answered that. Thank you.
Chairman Pruitt.
Mr. Chairman, I'd like to make a motion to pass at an appropriate time.
Okay. I do not see any more questions, and we have a motion on the floor. Hold on a second. I'm sorry. We did have some people that asked to speak, and you were free to waive that right. James Williams from the Carpenters Regional Council, and I would just ask that just be brief as possible if you can.
Okay. Yeah, this statement was written by Brett Hume, who's actually from the Carpenters Regional Council. He's not here, he's in Savannah, so I'm just going to say it in his stead. Chairman, committee, thank you for allowing me to speak. This is from Brett. Thank you for accepting the comments by proxy, as I have a prior engagement in Savannah this afternoon. House Bill 789 brings several major concerns. One is the concept of the marketplace contractor, as defined, invites exploitation of independent contractors in general, not speaking on Handy, but just in the legislation. This explosion guarantees that fewer Georgians will be protected by safety nets such as workers' compensation, unemployment insurance, employer-based health care, retirement funds, resulting in families and taxpayers being liable for those expenses. The marketplace contractor concept encourages system abuse. 2 weeks ago today, the Commissioner Butler reported that his committee is having a major staff reduction and funding shortages, and this creates a compliance issue on vetting and making sure, double checking those people are licensed. What mechanisms are there to prohibit one marketplace contractor from multiple representations, thus padding the list with multiple names on there to guarantee they get the bid? If the marketplace contractor currently is properly classifies their workers as employees, playing by the rules that all appropriate tax responsibilities are satisfied, are they prohibited from entering the marketplace platform because it says there that they're an independent contractor? Since they would be having to bid this work at about a 20% disadvantage to people that are independent contractors, because they're not having to pay the workers' comp and stuff. And also, his main statement was, how can the state of Georgia clarify an independent contractor for a digital network of digital employees and not statewide, not for every instance of employee and independent contractor? And that this further muddies the water between employer and independent contractor status. A clearer approach would be better clarification of this criteria that separates employee and independent contractor status throughout the state. Thank you.
Okay, thank you. Jonathan Wallace, you still here? Okay.
Thank you, Mr. Chairman. Thank you, committee. So I just wanted to add a couple of comments. So a lot of the discussion here has been around the concept of folks hiring out manual service. I come from a background of software development, and I just wanted to speak in favor of this bill, in that folks in my industry, when we're a startup, we're often looking for help building out a website. We want to look for designers or software developers, and in those situations, I think it's very nice for us to have a nice, clear definition of a subcontractor to make it very clear as to what that relationship is. And so that's what I wanted to share today, and make us think that it's not just the folks who are coming out and doing manual labor, there's also other aspects that are affected by this. Thank you.
Thank you very much. Mr. Clark.
Thank you, Mr. Chairman, members of the committee. I'm Bill Clark on behalf of the Georgia Trial Lawyers Association, and I will start by saying we do not oppose the bill. We have some concerns, and I appreciate the work of Handy, their lawyer, their lobbyist, and Representative Fleming to address some of our concerns. But I do want to raise a couple of other concerns for you. I want to let me back up just a second and give a tiny bit of background to where some of this began, just to sort of further flesh out some of Representative Fleming's introduction. Handy.com has been involved in pretty significant litigation around the country about what is and what is not an independent contractor. There are allegations that they began as a cleaning company, as I understand it, and they required them to wear uniforms and to even greet customers in a certain way, and it was the Handy.com way. Well, that tends to be in the employee arena rather than the independent contractor. Whether those are right or wrong, that's where this started, was can a company be truly just an internet app company, a platform company, where they have no control over the time, manner, and method of the job being done? And if so, then those folks are independent contractors. But if the lines are blurred, then it begs the question, are those people independent contractors or employees? And the reason that's important to the lawyers that I represent and the clients whom they represent is who, at the end of the day, is going to be responsible if someone is harmed. And while the General Counsel indicated that these folks are required to have insurance of various kinds, there's no indication that in the bill. And there's a lot of discussion about that during the Uber debate, and you required Uber to have certain levels of liability coverage, although they are, I would submit to you, very, very similar to what Handy.com does. We frankly aren't concerned about Handy.com because from all appearance and from our research, they are a great company. They do a good job of vetting people the right way. But what if not Handy.com comes to town? And they're going to be a fly-by-night operation. And they're going to hold themselves out to the public as being this great protector and provider to the consumer. They're going to say online, perhaps in their website, that we have a trust and safety commitment to you. Doesn't that say that they are going to stand behind the quality of work that the independent contractors provide? And if so, doesn't that again blur the line? At a minimum, they should have to notify the public that we do not have responsibility for these independent contractors. They have responsibility for what they do because we don't control the time, manner, and method of their work. And so we would like to ask you to consider a couple of amendments. Representative Part will present them when the chairman says that's the appropriate time. But I just want to lay out a couple of ideas for you to consider. They've done a good job. Representative Fleming and the General Counsel have done a good job of identifying a few of the key factors that the case law does require parties to go through and to demonstrate the lack of control. And those there are about 6 or 7 conditions that an independent contractor has to meet, or a service provider has to meet under this bill. We submit to you there ought to be a couple of more, and that's because these two I'm going to suggest to you are throughout the cases. All of the cases reference these two that we would suggest to you. One is that the marketplace company does not provide instrumentalities, materials, or tools for the performance of the work. If I've got a company and I hire you and I give you the tools and I tell you where to use the tools and how to use the tools, I'm your employer. I'm not hiring you as an independent contractor. I am controlling the time, manner, and method of what you do. And so we believe that they should not be allowed to provide the instrumentalities, materials, or tools for the worker to do the work. Secondly, we believe that we ought to just state what the general principle of law is. And I would tell you, if you asked any lawyer what's the law in Georgia dealing with independent contractors, and they would say, does the entity hiring them or bringing them to the consumer, do they have the right to control the time, manner, and method of the work being performed? And if they do, then the person is not an independent contractor. If they do not, then they've met that condition and would not be, or would qualify as an independent contractor. And this is the third part of this first suggestion that we make. In our hospitals right now, there are tons of medical providers who are independent contractors. They are not employees for the hospital. The hospital is not responsible for the work that they do. The hospital is not responsible if they commit malpractice and harm somebody. But under Georgia law right now, hospitals have to post where patients can see at the admissions office and ER and wherever patients come in, that we have independent contractors providing medical services here in our hospital. And we are not responsible for the work and for the acts or omissions of what they may do. They, the independent contractors, are responsible for that work. We believe the people in Georgia who are buying these services ought to have that same protection by requiring these platform companies to indicate that. They've got lots of things they indicate on their website that tell you what a great company they are and how they stand by their services. Shouldn't they have to tell Georgia citizens that while these are not our employees, they're independent contractors, we will have no responsibility if they commit some act or omission that results in harm to you? We believe that's a condition that ought to be in the bill. And lastly, whatever the debate is, this bill should only be prospective. In other words, it should only apply that once the governor signs it into law, it should only apply to services being provided after that time. If somebody did something 6 months ago and it's questionable whether they were doing it as an employee or an independent contractor, let's let the law that's in place right now deal with that, not have this bill be retroactive. And so we've suggested that you make it clear that services performed by anybody prior to the effective date will be covered by current Georgia law, not by this new code section. Again, I can't emphasize enough, it's great to be on the other side of an issue with someone you respect and someone you work with. And Representative Fleming, former Representative Ed Lindsay, and I have that relationship, and we will continue working with them to perfect, we believe, the legislation. We hope you will consider and adopt the amendments we've suggested, but we appreciate the time to be heard today, and I'm glad to answer any questions, Mr. Chairman.
All right, are there any questions for Mr. Clark or the previous two? Representative Carpenter.
Thank you, Chairman. Real quick, so would you consider the app itself for the supplier or the independent contractor to be a tool? Does that make sense?
That's a fair question. Representative Fleming asked me that because, as we understand it, Uber provides their computer or their laptop or their phone for that driver. I don't know the answer to that question. I think it's a fair question to ask. I would say that they aren't. When I think of the tools, I'm thinking, let's use the easy example of the brick mason we were talking about. If you've got your own lathe, you're an independent contractor. If I'm providing it to you, that's the tool that you're using to do the work, then you're more my employee. My honest answer to you is I don't know. That's a very fair question that we ought to look at. But that's one of the vagaries that the case law has handled on a case-by-case basis, and why, as Commissioner Butler said, we have to be very careful when we try to codify literally 200 years of case law into about 3 pages of codified law.
So, sorry, I turned my mic off. So maybe a suggestion for that amendment would be a tool that is free would be abstained from that. So if you give them your app for free, then it's not really providing a tool versus somewhere else you're providing a hammer. You know, that's it's going to cost you $10 or whatnot.
Well, I think if you are providing it to the worker for free, then you are providing them their tool. It might be better to frame it if it is. I don't want to do it on the fly. I respect y'all enough in the bill enough to say that's something we ought to work on further, because I believe that's a very fair question. Anything else, Mr. Chairman?
Any other questions? And I'm sorry, I had, speaking of Ed Lindsay on the list, after I grabbed the list, he was on the, so come on up.
Thank you, Mr. Chairman and members of the committee.
Lindsay, served on this committee for 10 years. God help you. It's better than judiciary, though. That's all I'll have to say. Regarding some of the points that were raised by Bill, and I represent Handy in this particular matter. The time, manner, and rather, first off, the tools issue that we chose here to sort of drill down and come up with more specifics, rather than a vague phrase. for instance, that you raised. For instance, the number 5 among the factors, rather than sort of itemized tools and what may or not be the tools, we simply say the marketplace contractor bears all or substantially all of its own expenses that are incurred in performance of the services. We believe that that encompasses the amendment that Mr. Clark suggested. Regarding time, manner, and method, I ask for you to look at 2, 3, and 4 among the factors that we have set out, which drill down into what time, manner, and method means here, which is basically, you don't have any specific hours, you can accept or reject work, you can do all the things that we've outlined in 2, 3, and 4. So we do cover those first 2 amendments that he suggested by simply giving greater specificity to the proposal rather than leaving a vague phrase that may bring these entities back into court and have to start going back through case law, which we're trying to avoid. Because this is, as Representative Fleming mentioned, an economic development tool. We're trying to bring these businesses into Georgia and to encourage them to come into Georgia and then help our independent contractors, to provide them with a vehicle that will help them get business and help them grow their own businesses down the road. So I think that's very important. But anyway, I think 2, 3, and 4 covers that particular issue. Regarding the notice issue, if we're going to start providing notice of all the possible things that an independent contractor may or may not be liable for, you're not going to have any room on a web page. And I'm not going to steal Representative Fleming's thunder, but he also has a very good analogy when it comes to lawyers. And I'm going to set him up, and then I'm going to be quiet, because I like his analogy. But it's his and not mine, so I'm not going to steal it here. Happy to take any questions.
Thank you. Any questions for Mr. Lindsay? Good, okay.
We thank you for your consideration.
So, Barry, did you want to say anything? We've got a motion on the floor.
I'll address my comments as we address the amendments,
Okay.
if you don't mind.
So, we've got a do pass motion on the floor. Do we have a second? All right, we've got a second from Mr. Kirby. Now would be the time, Representative Park, to introduce your amendments. Okay. All right, his motion was first. Is there a second?
Second.
All in favor of sending this to subcommittee, say aye.
Aye.
All opposed, say no. No. Do we want to do a show of hands, or are we clear on that? Okay. So that motion fails. So now we're going back to Chairman Pruitt's motion. We have a second from Kirby. Now we'll hear a motion from Representative Park. Do you have them written, or are you just going to read it to us?
The amendments should be in front of everybody. If not,
All right, does everybody have the amendment? Because I don't. Okay, gotcha.
So amendment 1 would delete on line 53, delete the word and then on line 56, insert the following additional categories to clarify the relationship of an independent contractor. The first, which addresses some of the questions raised, marketplace platform does not supply instrumentalities, materials, or tools for the marketplace contract doing the work. Number 9, the marketplace platform does not have the right to control the time, manner, or method, just to clarify, based on existing case law. And number 10, so that the people who are purchasing these services know that it is not Handy or any other app or market platform that will be responsible towards work done by the independent contractor. That it's a simple blank statement that marketplace contractors performing such services will be independent contractors. It's not a matter of waiving liability, it's just letting folks know. As a purpose of this is to clarify who is and who is not an independent contractor, letting it be apparent for customers to know that these are also independent contractors. So that would be amendment number 1. Amendment number 2 would be to strike line 62, or on line 62, delete the word or, and then on line 67, insert the following February 1st, 2008, or number 3, services performed prior to the effective date of this act. As as Bill Clark had previously spoken with the author of the bill, Representative Fleming, there's no more need for Amendment 3 as that was already addressed. So thank you, Representative Fleming.
You're welcome. May I address the amendments?
Yes, you may.
Mr. Chairman, in reference to amendment number 1, the reason I would ask my colleagues on the committee to vote against that is because instead of providing clarity to the law, which we're attempting to do, it is going to cause confusion, and let me explain to you briefly why. I want to say Casey. Big Daddy down here at the end has already pointed out one on number 8, and that is the fact that if we include the word instrumentalities in what can't be supplied, you're really bringing up the idea of can they have an internet platform to start with, because that is a definition, I would argue, of instrumentality. Number 9 there, wanting to control the time, place, and manner. If you look on line 41 of your bill on page 2, you see there that we already say they can't be controlled with specific hours when they can work. If you double down and say that twice, you will cause judges to try to figure out why you said it twice in the same bill if you already said it somewhere. You create confusion. You're going to create questions where they don't already exist. They're going to want to know why you addressed it twice. Doesn't that mean something? And number 10 there, this is really a marketing issue. This idea that there are independent contractors is already in the contract that you agree to when you hire this service. So if we want to introduce a bill that tells internet companies how to market things on their website, I think that's a fine bill. We can have a discussion with it. But this bill is not how to control their marketing. This bill is about what the definition of an independent contractor is and putting it into case law. So, you know, what Representative Lindsay was talking about is, I bet, you know, my good friend Mr. Bill Clark wouldn't want one of you introducing a bill telling attorneys what they had to put on their webpage. That, hey, if I mess up, you can sue me and I carry liability insurance. Some things are inherent that you know about, but we don't want to make them put on that one webpage where they can talk to everybody, tell them how much space they're going to use to say something that already exists. So, Mr. Chairman, for those reasons, I would ask that you vote against amendment number 1. In regards to amendment number 2, I believe I understand what Representative Park is asking, and that is already current law. When we pass this bill, we're not going to be judging people in the future, in the past rather, on what the law was then. We're going to be judging them on what the law is going forward if the case occurs at that point, as I understand it.
Okay. We're in a position of, we have a motion on the floor for Amendment 1. Is there a second?
Second.
We have a second from Representative McLean. All those in favor of Amendment 1, raise your hand. All those opposed, raise your hand. Okay, that amendment fails. You may now make a motion on Amendment 2.
Ask for the Second Amendment.
Second.
We have a second from McLean. What?
Could you repeat your motion?
For Amendment 2 to the piece of legislation that would
Yeah, he said do pass.
add.
Yeah,
for the
you were going for
Amendment
do
2.
pass.
Not do pass. It's,
Yeah.
Please restate your motion clearly
Yeah.
for us.
Yeah.
To amend lines 62 to delete or, and on line 67, insert after the following, or services performed to the effective date of this act.
Okay, gotcha.
And I second that
In
too.
second, okay.
Thank you.
Now, all those in favor with a show of hands. All those opposed. Okay, that motion fails. Okay, we're going back to the Pruitt do pass motion and second from Kirby. All those in favor, raise your hand. All those opposed. Okay, that motion carries. You are on to rules. There being no further business, this meeting is adjourned.